Hello friends, welcome to the second test discussion on Indian polity on NCERT. Fine. So the first question for you on the screen. The first question for this test. Consider the following. Number one, Zamindari abolition laws. Number two, nationalization of banks. Number three, fixing minimum wages. Number four, extradition treaties. How many among the above were enacted to give effect to DPSP? Fine. So the question here is directive principle of state policy. Now option number one only. Option B, only two. Option C, only three. And option D, all four. The question here is which among the following laws were enacted to give effect to DPSP? Okay. Now you know the basic plan of directive principle of state policy is welfare, isn't it? Welfare state. This is the plan of directive principle of state policy. Welfare state means you need to provide justice. Okay, justice is what is the ultimate aim of a welfare state. Fine. So number one says Zamindari abolition laws. Now, what does this mean? Zamindari abolition laws means the land which is owned by the zamindars would be taken away by the government and will now be distributed to the landless, isn't it? So, this is in fact for the welfare of the individuals, number one, and further contributes to the justice, isn't it? Number two, nationalization of banks. Again, very good. This is also a part of welfare. Say for example, you may have heard about amalgamation of corporation, isn't it? Amalgamation of corporation. So you have still under article number 31A, which says that the state may amalgamate, or the state may provide a law for the amalgamation of corporation. That means if one corporation, say for example, one company is company A is weak and company A is strong. Okay, company A is strong. Now the state can frame a law for amalgamating these two corporations or companies. Fine. So that also provides for a welfare state. Fixing minimum wages, of course, isn't it? To provide, say, for example, a living wage, which is part of directive principle of state policy, and extradition treaties. Extradition treaties means transfer of those accused from one country to another. So it is something in relation to the international treaties. Now you may say that predominantly only these three laws have a connection directly to the directive principle of state policy. Extradition treaties can also be linked to article number 51, that is for the promotion of peace as well as promotion of international peace and stability. You may say that article number 51 has got a connection with extradition treaties, but the most important laws in resonance with the directive principle of state policy is number 1, 2, and 3. This can be interpreted as an extension, but as per our official answer key, we have the answer that is option C, that is only 3. Okay, heading to the next question. Consider the following. Number 1, social, economic, and political justice. 2, right against economic exploitation. 3, prevention of slaughter of useful cattle. 4, promotion of village panchayat. How many among the above principles are included in the directive principle of state policy? Sir, you may just see this social, economic, and political justice. Very good. It is provided in article number 38 of the Indian Constitution. Right against economic exploitation. Yes, you are not supposed to, or your DPSP itself provides for just and humane conditions of work, isn't it? Just and humane conditions of work. Just and humane conditions of work. So DPSPs are those instructions provided to the state to interfere. That is, the Constitution says the state, please interfere in framing laws for providing just and humane condition. So there should not be any economic exploitation. Yeah, of course. So option 2 also comes under that category. Number 3 is prevention of slaughter of useful cattle. Again, that also comes under the category of DPSP. Promotion of village panchayat, article number 40, again comes under the category of DPSP. So in fact, all the four options comes under the category of directive principle of state policy. Okay, all these principles are included in part 4 of the Indian Constitution. Those are directions. Okay, directions to the state. Okay, directions to the state to establish a welfare state. Okay, establish a welfare state and uphold social as well as economic justice. So this is actually the intention of directive principle of state policy. The next question: which among the following issues was resolved after being an executive judicial conflict over the relationship between rights and directive principles? Sir, executive judicial conflict. Yeah, very good. So, right to property was always a controversial subject. Right to property was always a controversial subject because of the reason that, according to the original constitution, right to property was provided as a fundamental right, isn't it? Under article number 19 as well as article number 31, you had right to property which was protected as a fundamental right. But later, we have found that if right to property is fundamental right, then how can the state acquire the property? Because this is guaranteed right, isn't it? How can the state acquire the property? The state or the individuals may demand huge compensation, and the compensation would be a matter of controversy always. So later right to property was omitted from part 3 of the Indian Constitution, and we have made right to property as just a legal right. So now it is not a fundamental right at all. It is just a legal right under part 12 of the Indian Constitution. Very good. So right to property was omitted from part 3 of the Indian Constitution and was put in part 12 of the Indian Constitution under article 300A. Okay, under article 300A. Now right to property is just a legal right. It is no more a fundamental right. So the question is, which among the following issues was resolved? Sir, the issue which was relation to the right to property was resolved, isn't it? Was resolved after being an executive judicial conflict. Why it was an executive judicial conflict? Whenever the state says, the executive says, I am going to take your property, the individual will approach the Supreme Court. Now the Supreme Court will say that the state, you are not supposed to touch this property because this property is the fundamental right of this individual. So this is why option C, that is right to property, is the right answer. Fine. The next question: consider the following statements about the directive principle of state policy. Fine. Statement number 1: they are incorporated in the Constitution but not made legally enforceable. They are incorporated in the Constitution but not made legally enforceable. The first statement says that DPSPs are provided in the Constitution, but they are of non-justiciable nature, non-enforceable nature. Very good. So statement number 1 is correct. Statement number 1 is correct means you have three options: 1, 2, 3. Very good. So we are going for the second statement. Statement number 2 says courts can enforce certain provisions in the directive of state policy under Article 142 to provide complete justice. Sir, this statement is wrong, isn't it? Courts does not have the capability to enforce a DPSP until and unless the parliament comes forward with a law. This statement is wrong, which means option C would be the right answer, because statement 1 is correct. But statement 2 is incorrect. Are you getting the picture clear? So this is how you need to approach these kind of questions, because both of these options, you see this statement number 1 and statement 2 are correct, isn't it? Statement 1 and statement 2 are correct. Statement 1 and statement 2 are correct. Statement 1 is incorrect. So that itself eliminates this particular option. So C or both, I mean all the three other options gets eliminated. You would easily be able to get into the answer. Fine. The next question, consider the following. Number 1, formation of a uniform civil code. Wonderful. Speaking about article number 44. Very good. So article number 44 instructs the state, you please try to implement uniform civil code. What do you mean by uniform civil code? Is it the uniform parliamentary law? No, we are speaking about a uniform personal laws, isn't it? Religious laws, personal laws, succession laws, hereditary laws. These are the things we are speaking about, my dear friends. It is not parliamentary laws. Number 2, separate judiciary from executive. Very good. We are speaking about article number 50 of the Indian Constitution, which says that the state, you please take the actions, the executive, the legislature, you please take the action to separate the legislature or to separate the executive wing of the government from judiciary in public services. So there should not be mixing of judicial as well as executive functions in the same public office. That is the idea, isn't it? You earlier had the district magistrate who was performing the judicial as well as the executive functions, but later now the district magistrate is somebody who is under the authority of the high court, isn't it? So he will perform the judicial function. Now the district collector will perform the executive function. So that was separated. So that is on the basis of article 50 of the Indian Constitution. No discrimination across religion. Hey, no, this particular thing is not at all a DPSP, because religion is something that we have discussed already as part of the fundamental right in part 3. There is nothing in relation to religion in DPSP. Organized village panchayat, very good. Article number 40 of the Indian Constitution says to organize village panchayat. Is it to establish village panchayat? No, it is to empower village panchayat. Okay, empower village panchayat. Now the question we are going to guess, the question would be how many of the above would come under the category of DPSP. We'll just see this. How many among the above reflect the liberal intellectual nature of the DPSP? Sir, it is not asking about DPSP. They are asking about the liberal intellectual principles. Liberal intellectual principle means you have 1, 2. Will this come under the liberal intellectual principles? No, sir. This is just a Gandhian principle. This is Gandhian principle. So the constitutional experts have categorized DPSP into 3. Okay, the constitution does not classify. This classification is not mentioned in the constitution. The constitutional experts has classified DPSPs into number 1, Gandhian principles, number 2, socialist principles, number 3, liberal intellectual principles. Okay, so liberal intellectual principles means those principles that keeps on changing according to the time. It is something in relation with the time, isn't it? With the society, with the time, that keeps on changing, keeps on updating. So those kind of principles are liberal intellectual principles. So answer for this question is option B, only 2 of the options. Fine. Yeah. The next one, consider the following statements. Number 1, there is a lack of social and economic rights in fundamental rights. Very good. The Constitution provides provisions for the suspension of fundamental rights. Fantastic. The right to property was a fundamental right. How many of the above statements are correct? What do you need to choose? The correct statements, isn't it? Now we are again going through the statement. There is a lack of social and economic rights in fundamental rights. So lack of social and economic right means, yeah, up to some extent you can say that there is lack of social and economic rights, because fundamental rights were predominantly of the interest of upholding political democracy, isn't it? Political democracy. So the first statement is right. There is reduction when you compare with the political rights. There is lack of social and economic rights in fundamental rights. Very good. The constitution provides provisions for the suspension of fundamental rights. Of course, sir, the President of India can suspend fundamental rights through a notification when there is an emergency declaration. Yes, the Constitution provides for this. The right to property was a fundamental right. It's not a fundamental right now. It was a fundamental right. Very good. So this one is also correct. Now, what we need to choose? The right statement. So all three options are right. Very good. Fine. The next statement, the next question that we are going to deal here is, consider the following statements regarding the difference between fundamental rights and directive principles of state policy. Okay, fundamental rights and directive principles of state policy. Statement number one says, unlike the fundamental rights, DPSP are not enforceable in court. Very good. Unlike the fundamental rights, DPSPs are not enforceable in court. Statement number two says, fundamental rights have legal sanctions while DPSPs have moral and political sanctions. Which one of the following is correct with respect to the above statement? So you have the options here. Now, we need to understand the essence of both of these statements first. So, the first statement says, unlike the fundamental rights, directive principles of state policies are not enforceable in courts. So, fundamental rights are guaranteed rights. These are those rights which are guaranteed by the Constitution, enforceable by the court. Now, DPSPs are non guaranteed rights, or you may say DPSPs are rights out of Part 3 of the Indian Constitution. That means out of fundamental rights, you may say. So, now how DPSPs can be enforceable? So, DPSPs can be enforceable through elections. Okay, through elections. You can make the executive, you can make the legislature to follow these principles through public opinion, through elections. So that is what is provided here. Fundamental rights have legal sanctions while DPSPs have moral and political sanction. It is the moral obligation of the state to apply these principles, isn't it? So both of these statements are correct. Now, what we need to understand is that whether this particular statement provides for the explanation of statement number one or not. Okay, both statement is correct. Fine. Where is that option? This is also right. Okay, both statement one, statement two are correct. Statement one, statement two are correct. Now, is it providing any kind of explanation for statement number one? No, sir. It is not the explanation of statement number one. So, answer for this question is option B. Fine. Option B. Very good. Now, the next question, the eighth question. Consider the following statements with reference to equality before law and equal protection of law. Very good. We are going to speak about article number 14 of the Indian Constitution. Article number 14 says that Article number 14 says that no person shall be deprived of, no person shall be deprived of equality before law or equal protection of law within the territory of India. Within the territory of India. Fine. Yes. So two principles or two phenomenons have got explained here: equality before law, equal protection of law. Both the concept equality before law and equal protection of law is British origin. No, sir, equality before law is British, but equal protection of law is US. Fine. Equality before law is considered as a negative concept and equal protection of law is considered as a positive concept. Now, this statement is wrong and this statement is right. So, equality before law is considered as a negative concept. What do you mean by equality before law? Equality before law means, see, the law is same for all, or the application of law is same for all. You just imagine the condition that two individuals, one mentally unstable, one mentally very stable, both of them have committed a kidnap. Now just understand, if you apply the same law in the same way to both these individuals, then that is what do you mean by equality before law. Now, is it logically or is it reasonable that you apply the same level of law, same application process to those two individuals on different situations? Isn't it? One is mentally unstable and one is stable, and they have committed the same offense. You are applying the same law. Now, this is negative. So, this statement is a right statement, isn't it? Now, while the equal protection of law is considered as a positive concept, what do you mean by equal protection of law? You are just specifically or specially treating the mentally unstable person because he is mentally unstable. You are taking into consideration the mental status of this person. This is what do you mean by equal protection of law. You are protecting that person with the law, isn't it? So this is what do you mean by equal protection of law. Now this is going to be a positive concept. So statement number 2 is correct. Both concepts aims at establishing equality of legal status, opportunity and justice. Wonderful. So this is the same statement which is provided in NCERT. So this is also one of the objective of equality before law and equal protection of law, that is same legal status, opportunity as well as justice. The predominant consideration always is, my dear friends, justice. So what is the right answer? How many of the above statements are correct? Sir, two statements, only two statements, that is 2 and 3. Very good. The next question, question number 9. Consider the following categories of rights. Okay, following categories of rights. Number 1, constitutional rights are rights enshrined in the constitution, which is basic. Constitutional right means all those general rights provided in the constitution. Very good. Human rights become available to individuals by virtue of their birth as human beings. Sir, that is not human rights. It is in fact natural rights by birth. Okay, natural rights. Say for example, the rights like right to life. So those are natural rights. It is not human rights. This statement is wrong. Fine. Legal rights are rights conferred by the statutes enacted by the legislature. Very good. This statement is also right. Say for example, your right to information. Right to information as per the Information Act, the Right to Information Act. Yes, it is a legal right also. So legal rights are rights conferred by the statutes enacted by the legislature. 1 and 3 are correct. 1 and 3. Sir, 1 and 3 means you can eliminate this option. Now you have 3, isn't it? Natural rights are rights considered fundamental to human dignity and well-being. Oh. Sir, this is in fact human rights. This is in fact human rights. So there is a just deviation, tilt. That is, the explanation of human rights needs to be substituted with a natural right. So it is just a kind of making you confusing. Okay. So human rights are rights considered fundamental to human dignity and well-being. So the answer for this question is 1 and 3 only. Wonderful. So this is the answer for question number 9. We will move to next one, question number 10. Consider the following statements. Number 1, right to be forgotten was a part of the broader right of privacy under Article 21. So what do you mean by right to be forgotten? Say for example, when you go to the search engines, sometimes you may say that your password is something which you do not remember, isn't it? Yeah, that is not an issue because you will be having the mechanism to make it remember with other connections. So that is also your part of right to privacy. Very good. So this is actually a right statement, isn't it? So when you forgot or when you forget the password, the search engine will provide you the alternative if you have the connection to regain the password or to recreate the password, only if you have the connection. So this is something which is very private. Fine. So this statement is right. Second statement says the right to privacy is declared as a fundamental right in case Puttaswamy versus Union of India case in 2017. Are wonderful. So this statement is also right statement. Right to privacy is always connected with case Puttaswamy case, isn't it? So this statement is also right. Option number 1, 2 are correct. Very good. Correct statement is what is asked. Question number 11. Consider statements regarding constitutional remedies. Very good. Constitutional remedies means when there is a violation of fundamental right, you are provided with certain rights to approach the Supreme Court of India, isn't it? The right to constitutional remedies under Article number 32 of the Indian Constitution. So, number one, statement number one says it is the right to approach any court to get any of the fundamental rights restored in case of their violation. Sir, no, sir, it is not the right to approach any court. This particular statement is wrong, isn't it? It is the right to approach the Supreme Court. Constitutional remedy. It is the right to approach the Supreme Court. Fine. Statement number 2 says a writ of prohibition means the transfer of a matter pending before a lower court to a higher court. Sir, there is no transfer of matter. There is no transfer of matter from a lower court to higher court. Writ of prohibition means just a stay order. That's it. It is just a stay order. The higher court says the lower court, stay, stop, enough is enough. This is what is the writ of prohibition. Writ of habeas corpus can order to set free an arrested person even if the manner of arrest is lawful. Sir, if it is lawful, how can the writ of habeas corpus say to release that person free? Because this is lawful. If this is lawful, why should that person be set free? Isn't it? It is just application of logic. So here, all these statements are wrong and the answer is option D, because you are supposed to choose the correct statement. None of the above statements are correct. Very good. Question number 12. Which of the following statements does not reflect a valid criticism of directive principle of state policy? Number 1, DPSPs have reduced significance because fundamental rights are justiciable while DPSPs are not. We need to choose valid criticism of DPSP, isn't it? The first criticism says that the fundamental rights are justiciable. And what is the point of providing DPSP separate? And you are just making DPSPs as non-justiciable. Then what is the importance of DPSP? Yes, sir, this is one of the valid criticism. DPSPs are drafted in a broad manner, leading to ambiguity in understanding the state's responsibilities. Yes, this is also one of the valid criticism. Why? Because certain DPSPs are very general in nature. Say, for example, like the improvement in the quality of life, or the state may frame laws for the improvement in the quality of life. Another DPSP says about to provide just and humane working conditions, isn't it? All these are general. It is not very specific. So this particular criticism is also valid. Third one, the original constitutional vision gets diluted with every amendment made to the DPSP provisions. My goodness, no. In fact, the original constitution gets value addition, isn't it? The original constitution gets value addition. Say, for example, the original constitution was not having a DPSP to provide for free legal aid. So 39A, as per the 42nd Constitutional Amendment Act, Madam Indira Gandhi has decided that we will insert an article to provide free legal aid. Free legal aid. Those who are actually wanting a free legal aid, we will provide that. So that is what is article number 39A, and now it has actually added a value to the directive principle of state policy. So the original constitutional vision gets diluted. No, sir, it does not get diluted. So this option C is incorrect. It is not a valid criticism at all. So you will get the answer by this. We will see the last option also. Overemphasis on socialist policies in DPSP, undermining individual property rights. No, sir, this is also not a valid. Okay, this is a valid criticism, isn't it? Overemphasis on socialist policies in DPSP, undermining individual property rights. So DPSP under article number 39C as well as article number 39B says that the state may acquire the property. So what about the individual property? Isn't it? So it is undermining the individual property rights. So this question will have the answer option C, which is invalid criticism. The original constitution is getting a value addition. Question number 13. Consider the following statements about fundamental rights ensured by the Constitution. Statement number 1. These are unlimited rights. No, sir. Fundamental rights are always subject to reasonable restrictions. So the first statement, without going to the next part itself, is wrong. The Constitution has separately listed them and made special provision for their protection. Yes, the Constitution has provided part 3 in the Indian Constitution, starting from Article 12 to 35 as a separate part to protect those rights. Executive as well as legislative actions can be declared illegal by the judiciary if these violate fundamental rights. Very good. So executive actions, be it orders, rules, regulations, legislative actions like the laws, acts, those can be declared illegal or invalid or null and void by the judiciary if this violates fundamental rights. So 2 and 3 are right statement and you need to choose the correct statement. So option C, 2 statements only is the right answer. Very good. So the next question, question number 14. Consider the following statement. Some fundamental duties are moral duties while other are civic duties. Very good. So some fundamental duties. So fundamental duties are duties of the citizens of India. Some fundamental duties are moral. Say for example, like to cherish, or say for example like to cherish the noble ideals of the national freedom struggle, isn't it? So those are actually moral duties. That means it changes according to the person, isn't it? So there are some kind of moral duties as well as there are some kind of civic duties. Say for example, to respect national anthem, to abide by the constitution. These are civic duties. Fine. So first statement is right. Statement number 2 says fundamental duties are applicable to citizens and foreigners. My goodness. Sir, fundamental duties are applicable only to citizens of India. You may think that fundamental duties may get applicable to the foreigners also. No. Fundamental duties are the duties which is applicable only to the citizens of India. Okay. Fundamental duties are non-justiciable like DPSP. Very good. So fundamental duties are non-justiciable. Right statement. So option number 2 is wrong. So the answer for this question is option C, that is 1 and 3 only. The next question, 15. Which of the statements is not correct? Fine. So we need to choose wrong statement about the cultural and educational rights in the Constitution. Okay, about the cultural and educational rights in the Constitution. So you are speaking about article number 29 as well as article number 30 in the Constitution. Very good. All communities of citizens have the right to conserve their language, script, or culture. So all communities. Yes, all communities. So this is provided under article number 29, which says that in fact the title of article number 29 says protection of interest of minorities. But the script says any section of citizen, okay, any section of citizen shall have the right to conserve their language, script, or culture. So there was a confusion, and this confusion was resolved by the judiciary, the Supreme Court, and the Supreme Court said, does not matter being it minority or majority, any section of citizens, both minority as well as majority, will have the right to conserve the language, script, or culture. So option number A is the right statement. So what you need to choose? The wrong statement. The state can disburse the financial assistance to those minority educational institutions which were defined by the Constitution. Sir, no definition by the Constitution. Wrong statement. All minorities, religious or linguistic, can set up their educational institution. Very good. Article number 30. Educational institutions established by minorities are open to all, irrespective of the students' religious or linguistic background. Say, for example, the Jamia Millia University is established by a minority, and there are Hindus, Christians, Malayalis, Bengalis, every kind of linguistic or the religious groups are part of that particular institution. So this as well as this, right, wrong. One is option B. Fine. So the next one is, consider the following statement with respect to the right to property. The first statement says, so we are going to deal with the right to property here. 42nd Amendment to the Constitution removed the right to property from the list of fundamental rights. Sir, it was not 42nd Constitutional Amendment, it was 44th Constitutional Amendment Act of 1978. So this statement is wrong statement. Okay. 300A says deprivation of property only from arbitrary executive action. Now this statement is right, isn't it? Which means now the right to property is only a legal right, isn't it? Only a legal right, which means there is no guarantee for the compensation. There is no guarantee for the compensation. If it would have been the fundamental right, there would have been a guaranteed compensation. And that was actually the reason for the controversy. Now, here you do not have a guarantee, which means a law can be framed by the legislature to acquire your property. So you do not have a guaranteed compensation. Okay. So this one statement is right. The doctrine of eminent domain confers power on the state to acquire property for public purpose. Yes, sir. Statement number 3 is also right. What do you mean by doctrine of eminent domain? Doctrine of eminent domain actually confers a power for the state by providing the suitable compensation to acquire the property. So option number 2 as well as 3, right statement. The question here is, the correct statement needs to be chosen. Answer here is only 2. So the next question, question number 17. Consider the following statements. Fundamental duties of citizens got inserted into the Constitution by the 44th Constitutional Amendment Act. Absolutely wrong. Did you know 42nd? Everybody know, even the non-serious UPSC aspirants would be knowing this particular fact. That is 42nd Constitutional Amendment Act of 1976. The first statement is wrong. The Constitution empowered the states to adopt mechanisms to enforce fundamental duties in contingencies. No, sir, the Constitution does not say about any of the mechanisms to make the fundamental duties enforced in the times of exigencies. No, the Constitution does not say. The Constitution does not make the enjoyment of the rights dependent upon the fulfillment or conditions of duties. The Constitution does not make the enjoyment of the rights dependent upon the fulfillment or the conditions of duties. Yes, this statement is right. Why? Why? The Constitution does not say that if you perform the duty only, you would be able to enjoy the rights. This is what is provided here. The Constitution does not make the enjoyment of the rights dependent upon the fulfillment or the conditional of duties. So the answer for this question is option C, that is 3 only. Fine. Next one, question number 18. Very simple question. Which of the following articles take away the spirit and substance of the fundamental rights through the provision of preventive detention as generally claimed by the constitutional critics. Which one of the following articles speaks about the preventive detention? Simple question. Article number 22 speaks about the preventive detention. Fine. Now, question number 19. Consider the statements about the fundamental duties in Part 4A of the Indian Constitution. Many of the provisions refer to such values that have been part of Indian tradition and practices. Yes, in fact, many of the fundamental duties were already been considered as part of our traditions as well as mythology, isn't it? To value, to preserve rich heritage, all those kind of things are considered as one of the duties that we already is performing. Okay, it aims to create a kind, just a second, yeah. Statement number 2 says that, so the first statement is correct. It aims to create a kind of enlightened citizens who give primacy to public interest over narrow private interest. Yes, fundamental duties are actually a kind of idea to make remember about the citizens of India that you enjoy rights, isn't it? You enjoy rights. Fine. Now you will have to perform something back to the state. So you enjoy rights, now you will have to perform something back to state. So this is what is the idea of duty, and it is always in the public interest. Fine. So both the statements 1 and 2 are right. Fine. Question number 20. Consider the following rights. No tax shall be levied or collected except by authority of law. Very good. Right to vote in elections, prohibition of employment of children in factories, no person shall be deprived of his property except by the authority of law, right to constitutional remedies. How many of the above mentioned rights are constitutional rights outside fundamental rights? So we will understand which all are fundamental rights now. Fundamental rights, fundamental rights. Does others come under the category of fundamental rights? No, this is actually one of the right to property, which is legal right. Right to vote in election, yes, another constitutional right. No tax shall be levied, yes, another constitutional right. So the answer for this question is 1, 2, 3. Only 3. Okay, only 3. So out of 5, 3 are constitutional rights out of part 3 of the Indian Constitution. Question number 21. Consider the following: protection in respect of conviction of offences, protection of life and personal liberty, right to elementary education, protection against arrest and detention in certain cases. Very good. Now, what is the question? How many of the above come under the right to freedom? So, right to freedom is mentioned under article number 19 to 22 of the Indian Constitution. Now, Article number 19 provides for the protection of six freedom, isn't it? The protection of six freedom. Say, for example, the freedom of speech and expression, the freedom to assemble peacefully without arms, the freedom to travel within the territory of India, the freedom to practice any profession, all these things, the freedom to settle in any part of the country, all these things are provided as part of Article number 19. Article 20 speaks about the protection, okay, the protection in uh, the protection against or the protection in case of conviction, isn't it? The protection in case of conviction. Article 21 speaks about 21 in fact speaks about the right to life and personal liberty. Fine. 22 speaks about the right or the freedom, the right to or the right against arrest and detention, isn't it? Right against arrest and detention. So article 19, 20, 21, 22. Very good. So protection of life and personal liberty, article number 21. Protection in respect for conviction of offences, article number 20. Protection against arrest and detention in certain cases, article number 22. Sir, but right to elementary education? Yes, sir. In fact, that is also one of the right which was inserted as part of right to education, isn't it? By or you may say that the right to education was inserted to this particular range in between 21 and 22. That is, you have article number 21A. Okay, 21A of the Indian Constitution, that provides for the right to elementary education as a fundamental right. It was not originally part of the Constitution, it was later made part of the Constitution by an amendment. So all the four statements are part of the right to freedom. Okay, the right to freedom. Very good. Now the next statement. Statement number 1, our constitution ensures that persons accused of various offenses also get sufficient protection. Sir, it is just an accuse, isn't it? Or it is just a kind of accusation. It is just a kind of allegation, not accusation. In fact, it is just a kind of allegation. The person is only an accused. He is not guilty. So the accused will also be given certain protection. Very good. Second statement says no one is guilty unless the court has found that person guilty of an offense. Nobody is guilty until proved, isn't it? So this is in a way the explanation for the first statement. Now, what is the correct answer? Both statement 1 and statement 2 are correct, and statement 2 is not the correct. No, sir, this is not the answer. Both statement 1 and statement 2 are correct, and statement 2 is the correct explanation for statement 1. Very good. So statement 2 is the correct explanation for statement 1. Question number 23. Consider the following regarding preventive detention. It is a doctrine developed by the judiciary and finds no mention in the constitution. Absolutely wrong. Judiciary has got nothing to do with preventive detention. It is provided in the constitution as per article number 22. We have already discussed this. So this statement is wrong. A person can be arrested simply out of an apprehension that he or she is likely to engage in unlawful activity and imprisoned for some time without following normal procedural guidelines. This is known as preventive detention. So preventive detention is actually a prevention. Okay, prevention from this person not committing a crime in future, or you may have an apprehension that this person might commit a crime in future if left free. So you are putting that person under detention. Now this is what do you mean by preventive detention. Right statement. Preventive detention can be extended only for 3 months. After 3 months, if you need to extend preventive detention, you will have to get the opinion of advisory board. Fine. So this statement is also right. So usually preventive detention gets extended only up to 3 months. If you need to extend preventive detention beyond 3 months, there is certain condition, and one of the condition is that it needs to be put into consideration of the advisory board. So two statements are correct, and you are supposed to choose the correct statement. So two statements are correct. Question number 24. Consider the following. Number 1, forced labor without payment or begar. Buying and selling. In fact, this is begar. Okay, not beggar. It is begar. Fine. Buying and selling of human beings and using them as slaves. Employment of children below 14 years of age in dangerous jobs like factories and mines. How many of the above are declared as crime per the constitution? Okay. Sir, forced labor is a crime. Begar is a crime. Buying and selling of human beings and using them as slave is crime. That is your commodification. You are just commodifying the individuals. Crime. Employment of children below 14 years. Hazardous activity. Crime. 1, 2, 3. All the above are determined as crime. Fine. The last one. The last question for today. Consider the following regarding freedom of religion in India. Freedom of religion includes the freedom to profess, follow, and propagate any religion. Very good. You can practice religion, you can profess religion, you can spread religion, the value of religion, you can spread the value of religion, isn't it? The government can impose restrictions on the practice of freedom of religion in order to protect public order, morality, and health. Suppose if there is a kind of a health emergency like corona, the government can say that in this particular year there is no practice of Attugal Pongala, isn't it? Yeah. So that can also be restricted. So statement number 1 is right, statement number 2 is right. The constitution does not allow forcible conversions even if the individual does not raise any voice against it. The constitution does not allow forcible conversion even if the individual does not raise any voice against it. Sir, the constitution does not allow forcible conversion. Fine. The constitution does not allow forcible conversion. So that is a right statement. So the answer for this question is, in fact, yeah, no, all three. Okay. The constitution does not allow forcible conversions even if the individual does not raise any voice against it. Yeah, the constitution does not allow any kind of forcible conversions. Okay. So that will end the discussion of the second test and the 25 questions on the basis of NCERT. So I hope you would have enjoyed this session. This is very crisp to make you most and more entertaining. Okay, so I hope you would be enjoying the sessions. Hope we will meet you soon. Okay, so thank you. Goodbye.